Welcome, everyone, to the PCI Practical Matters podcast. We're continuing our 10 myths of government contracting. This is myth number 4, and our speaker is still Tim Sullivan. Take it away, Tim.
Thank you, Fritz. Myth number 4. We will only work as a subcontractor because we don't want to be exposed the way a prime contractor is. How many times have you heard this? My response is always the same. Have you ever actually read any of your subcontracts? Now, I already know the answer to that question, of course, because no one who has read a properly drafted subcontract could ever utter those words. If a prime is doing its job, it's going to flow down many of the clauses from its prime contract to its subcontractors. Primes go about this in a variety of ways. Some will actually print each and every clause verbatim and include them in your subcontract. And they'll tell you that where the clause says the government, it means the prime. And where it says contractor, it means the sub. Others will simply list the clauses by title and leave it to you to look them up. Other primes might include clauses that look like they're standard clauses, but upon examination have been altered in ways that are adverse to the sub. These are camouflage clauses. And these are just a few of the things that can happen. Of course, with the volume of business that goes on, a sub might have several different deals pending at any given time. And the common complaint is that there is never enough time to do the review that is necessary before signing a subcontract. In other words, they sign the deal without really knowing what it is, and they hope for the best. In most situations, contracts can be performed with only minor glitches, so this ostrich approach might work at times. It might be just fine. But in those cases where a major problem arises, this approach can cause a lot of heartburn. While it is true that a subcontractor does not have privity with the government, that is, it doesn't have a direct contractual relationship with the government, that merely presents a procedural obstacle to Uncle Sam in terms of their having an ability to get to the sub. If the prime contractor has put the appropriate clauses in your agreement, there is almost no shield between your company and the government. Let's say, for example, that the government determines that your cost and pricing data are defective under the Truth in Negotiations Act. Because it has no privity with your company, the government will lodge the defective pricing claim and action against the prime, and the prime will turn around and file it with you. You will then have to work through and with the prime to resolve the problem. Now, this same two-step process would hold true for most standard contract actions. A change, for example, the government would issue the change to the prime turns around and issues a change to you if that change affects what you're doing under the contract. But there are situations in which the government, acting in its sovereign capacity rather than in its contractual capacity, can come directly against the sub. For example, let's say that your defective pricing matter has been referred to the Department of Justice, and the DOJ, the Department of Justice, concludes that your actions were criminal. The Justice Department can file charges against your company directly, even though it has no contractual relationship with you whatsoever. Likewise, if the Department of Labor should conclude that your company has failed to abide by the Service Contract Act or the Davis-Bacon Act, the DOL can move directly against you without going through your prime. Now, there's one particular area where being a subcontractor actually exposes a company to more risk than a prime, and that is payment. The prime is the beneficiary of a statute called the Prompt Payment Act from the early 1980s. And that statute puts pressure on the government to make timely payments. That statute does not apply to subcontractors. Instead, the subcontractor's payment will be governed by the language in your subcontract. So if the subcontract is silent on payment, Or if the language is of the pay when paid variety, that is, the prime agrees to pay the sub within a certain number of days after the government has paid the prime, the sub could be in a bind. What happens, for example, if the agency fails to make its first payment to the prime until 60 to 90 days after the contract performance began? That is not an unusual occurrence. If the subcontract payment terms are pay when paid, the sub is out of luck. That is why, to the extent possible, a subcontractor should insist on payment within a 30-day period from submitting the invoice to the prime, regardless of what the government or when the government actually pays the prime. Now, this often comes down to a matter of negotiation leverage. Most subs believe that they have no leverage in such situations, but that isn't necessarily the case. A sub's exposure may depend on two other important concepts: choice of law on the one hand and disputes on the other. A well-drafted subcontract will always contain clauses addressing these two issues. Without such clauses, the prime contractor will always be in the driver's seat. So let's talk about the choice of law first. That clause dictates what forum's law will govern the transaction. So this contract will be governed by the law of the state of California, or this contract will be governed, or this agreement will be governed by the law of the state of Wisconsin. It is yet another reminder that a subcontract is between two commercial organizations, and the prime usually will try to ensure that the laws of its home state will govern. That's not necessarily a bad thing. But if a sub is aware that a particular state, for example, is inhospitable to manufacturers, and you're a manufacturer, it might want to think twice about agreeing to be governed by that state's laws. Now, one way to mitigate this problem would be to agree that the subcontract will be governed by the law of federal government contracts, and that if a situation should arise where there is no such applicable law, then the law of the prime's home state would apply. That is a very common tool these days between and among companies that do a lot of business with Uncle Sam. So it's a very popular technique, and it avoids getting caught under the laws of a state that you don't want to be under. With respect to disputes, it's important to remember that there are two basic kinds of disputes in connection with subcontracts. There are first those disputes that are between the prime and the sub, failure to pay, for example. And there are those disputes that are really between the sub on the one hand and the government on the other. So your subcontract should contain a disputes clause that addresses both these types of disputes. In crafting the language addressing disputes between the prime and the sub, there are many possible approaches, but beware of a provision calling for binding arbitration. Arbitration may sound attractive because it avoids the courts, but in practice, it can be an expensive and frustrating experience with no way out. That's why I recommend highly using language that calls for some sort of alternative dispute resolution, ADR, some kind of ADR technique, and there are many, that will minimize the role of lawyers and the risk of uncontrolled litigation expenses. If it's not possible to agree on that kind of an approach, and litigation is the only option, be careful to avoid language that all such litigation will be conducted in the prime contractor's jurisdiction. Now, with respect to the language addressing disputes that are really between the government and the sub, it is important to track the disputes language from the prime contract so that the procedures in the subcontract parallel it. Every subcontract presents risks. A smart subcontractor realizes this and takes careful and prudent steps to mitigate those risks. The failure to do so could lead to some serious consequences.